Yeah, hello, welcome back to the channel. This is now some small lecture on EU law and taxation part 2 this time, and just let's go into the matter. Okay, yeah, the topic for today is the prevalence of EU law over national law. That means the fact that EU law, if there is a contradiction between EU law and the law of a member state, that EU law always wins the conflict. And that is sometimes a bit difficult to understand. That mostly comes from the traditional view of international treaties. Well, so let us begin with the traditional view, which is held for the interpretation of classical international treaties. So, what's normal? The normal aspect is usually that states are sovereign and that as such they want to preserve as much as their sovereignty as possible. So that says a state is the highest authority. A state can decide on its own which obligations they want to take and which obligations they want to follow. So for the making of international agreements, sovereignty means a state only enters an international agreement voluntarily, and it means as nobody can force the state to follow some rules due to its sovereignty, it also keeps an international treaty voluntarily. Yeah, and now for the interpretation of classical international treaties, that also means the states are supposed to, that they want to preserve as much as their sovereignty as is possible. And so classically, a law expert would always say what has not been explicitly promised in an international agreement shall not be added by interpretation, because that would affect the state's sovereignty. The idea is what is explicitly promised, that can be regarded as binding perhaps, but everything which has not been promised explicitly was not promised. So traditional view means in practice that if you have to deal with an ordinary international agreement, the interpretation will always stick to the strict wording, at least in all cases of doubt. So when, for example, Article 24 of most double taxation treaties follows the OECD Model Convention and says it's forbidden to discriminate between the nationals of the contracting states according to their nationality, then that is clear. But on the other hand, that means, well, if you discriminate on other grounds, for example, on grounds of the different places where these people live, inland or abroad, that is not forbidden by the treaty. That's permitted because the treaty only speaks of nationality and not of nationality or similar criteria. And the criterion that one could distinguish according to the place of residence, that's a well-known criterion. It was not mentioned, so it was not meant. It would also be allowed to invent new criteria of which the treaty doesn't speak and couldn't even foresee that they could be used. For example, discriminating between people on the grounds of their language skills would also be not forbidden because it had not been mentioned. Although in the final effect that mostly leads to exactly the same effect as if you discriminate on grounds of nationality. There was, by the way, even a decision from the German Federal Fiscal Court, the Bundesfinanzhof, from, I believe, 1990 or so, where they said, well, we promised not to discriminate between juridical persons on the grounds of nationality, but we discriminate on the grounds of their seat, their statutory seat. And that's not the same. Although, surprise, the statutory seat of a capital company or of a juridical person is what defines their nationality. So there was a 100% correlation between the seat, what came out due to the seat, Inland or Italian, and the nationality, German or Italian. So nevertheless, the court held this was not the same. So this is the traditional view, how international agreements should be interpreted. And if you want to sum that up in plain, clear words, you can say an international agreement is to be interpreted as if it is not meant serious, to be serious. So in the legal system of a state, of a sovereign state, there is no legal measure to enforce that that state really follows its obligations. They are taken voluntarily, they are followed voluntarily, and so the whole system of international agreements is usually to be understood as, okay, we mean it as long as we want to. So the whole thing is a sham. Huh? It's not meant serious. Now, if politicians or experts of a high level who do not specialize on matters of EU law, and other people who have grown up with that traditional view of international relations, when they are faced with the EU law system, they very quickly end up with fundamental misunderstandings or with inner emotional protests because EU law is completely different. The whole theory behind EU law says things which are completely different, and so everything in a classical law expert will revolt when it comes to EU law. Well, I'm no longer sovereign. I am no longer allowed as a state to decide what I do and not. An obligation means I have to follow it. That's an outrage for these people. But indeed, when it first became necessary to interpret the EU treaties, or the first variants of them, they were originally named differently. Then the courts, who had to decide how to understand EU rules, quickly saw that the whole thing has a completely different, framework. The EU law says we set up some central institutions. We give them the power to legislate, to create laws which are designed as binding. We set up a court which has explicitly the power to decide that a member state is wrong and violates the treaty. The member states are obliged to follow the court decisions. We have even legal procedures which make sure that if a court procedure is going on in a member state, that the opinion of the European Court of Justice on EU law can be asked for and has to be followed. And all that, the overall picture of EU law allowed only one conclusion. This legal system, in contrast to all the other international treaties, is a system where things are meant to be serious. Here, the member states have a serious wish or a serious decision to be serious with their obligations. So, in that legal surroundings, the word obligation must be interpreted as an obligation. And an obligation is something which you have to follow even if you do not want to do it. So that means that the rules for interpretation of this treaty system are completely different from all what you know from other treaties, and that is what people need to understand first. And in all cases of doubt, the fundamental assumption for the interpretation of European Union law is always that outrageous, revolutionary, and basic assumption EU law is meant serious. So that it has to have an effective, serious meaning. And that means, naturally, when it comes to that question of sovereignty, that if a state becomes a member of the European Union, this state effectively renounces on a part of its so-called sovereignty, especially or plainly everywhere where EU law has an obligation for that state. The sovereignty of that state will no longer exist everywhere where EU law speaks. That is a precondition for becoming a member of the European Union, and the whole legal system relies on that fundament. Now, sometimes that leads to theoretical question, especially experts in law indulge, or they like to indulge in theoretical discussions. Is that possible? If a state is really sovereign, can it restrict and cut back its sovereignty? Can you renounce on sovereignty fully on part? Yeah, there is from the one or other constitutional court of a member state, which then takes the view, well, traditionally a state only becomes voluntarily a part or a party of an international agreement, and they only voluntarily stick to it. They cannot be forced to follow an obligation which they took. So there you can find the idea that if a state says, I want to become a member of the European Union, then and I declare I will follow its obligations, so as serious obligation, then this is only my voluntary decision, and I can revoke that with full effect at every time. So that would mean you cannot renounce on your sovereignty. This is an idea which constitutional courts sometimes want to uphold. The idea is probably deeply rooted in their minds that they are the judges in the constitutional court and that they are the highest ranking judges in the state, and they want to remain it. That probably that these people have a kind of a subconsciousness and or subconscious ideas, and that is no, this idea is revolting. But let's think about theoretically about the idea that you can't renounce sovereignty. First, if sovereignty is defined as the legal power to take every decision that nobody can give you orders, then the question is, by which logic do you then justify to say sovereignty, that is the power to decide, to make every decision, excludes the power to decide that you want to restrict that power effectively, so that it is really effectively restricted afterwards? In that case, if you want to say that is forbidden, then you need to assume a higher power which is able legally to forbid the state to make such a decision. I want to cut back my sovereignty and give away a bit of it. Now the question is, if the state is defined to be sovereign, which higher power should that be, and could that be? So could that be the power of the law expert? That's a constitutional problem. Can you really say that a law expert is above the Constitution and above the state authorities on the basis of an own defined authority to decide what's theoretically possible. That's rather an interesting idea. It's probably a kind of a usurpation of power if you look to that. You could also say it's due to factual constraints that somebody who has the full spectrum of powers cannot cut it back. You cannot really separate that. The only thing where there is perhaps a difference is that you say, well, it's just real life. You can't cut back that. The problem is, in real life, it is possible to give away certain opportunities which you first have. For example, if I can freely decide in a kind of sovereign decision about what happens to my body or my person, I can freely take the decision to have my left leg amputated. Or, if you prefer a less drastic example, to have a tattoo made on my arm. Now, after I have taken and executed such a sovereign decision, the natural consequence of my decision will now be I can no longer recover my left leg. If after it has been amputated, it is gone. That was the consequence of your free decision. Now you can't bring it back. Gone. The same, logically, is expectable with the tattoo. If you once have the tattoo, you can never recover a tattoo-free arm. You can let the tattoo removed, but you can never get rid of all the traces. It's not possible to revoke the former state of affairs. By the way, it's a logical implication of all decisions that you have to choose, and when you make your choice, some alternatives are gone and can't come back. So that question, if sovereignty can include the right to renounce on it, that is not a new question. For example, when the famous Emperor Charles V abdicated as Holy Roman Emperor in 1556, the surprising reaction of the constitutional body, which was responsible for electing or recognizing a new emperor, the 7 prince-electors of the realm, was that they just simply refused to accept that the emperor was no longer the emperor. He had to convince them for more than a year that he regarded himself as no longer the emperor and that he was no longer the emperor. The argument of the electors was, if you have got your job by the grace of God, and if you have been appointed by God, it's not in your powers to get rid of that position. What God has given you can only be taken back by God. You should note first that the argument of the electors was so that sovereignty of the emperor did not include to end his sovereign position, but you should also note that the argumentation strongly relied on the idea that there was a higher authority than the sovereign, so on which the sovereignty of the sovereign here relied, and so that the sovereign was not sovereign under that legal system. And that is the flaw in the argumentation when one comes to arguing with sovereignty. When you define sovereignty as the position where there is nobody above you, then you get problems in arguing and giving good arguments for why you can't restrict or renounce on it. There was a similar case in recent times when the Soviet Union was ended in 1991. It was later decided in a resolution, at least I heard so, by the Russian parliament that this had been an illegal act and should never have happened, or could not be legally possible However, the Russian parliament did never go so far as to say that as this act was not allowed under the old constitution, it did not have an actual effect. So even if the Soviet Union institutions or the states of the Soviet Union had under its old constitution no powers to end up its sovereignty, they didn't dispute the fact that what happened was indeed that they did end its existence. So evidently things were possible in that way. That logical problem, by the way, is often solved or can be solved if one takes into consideration that from the point of view of international law, sovereignty is not a matter of law, but a matter of fact. If you read a textbook on international law, you will quickly come across that theorem that sovereignty or the existence of a state or non-existence of a state is a matter of fact. You can't create it, or you can't give sovereignty by a legal act to an institution. You can only acknowledge it as existing or not. So if sovereignty is a matter of fact, then perhaps it could not be legally shifted to the EU institutions or so. That was perhaps not allowed. But if that is what happened, this is then afterwards a fact, and a fact can no longer be denied. Also for this, we have some examples from history which can illustrate that. For example, you know, again, the Holy Roman Emperor of the German, the Holy Roman Empire of the German nation. That was the official state name of Germany until 1806. When the last emperor of that empire was forced to abdicate by Napoleon, he renounced the crown and he declared the Holy Roman Empire as ended, terminated by virtue of his abdication. So he said, I am the last, I lay down the crown, and that's it. So the empire is gone. Legally, that was definitively not possible. However, the fact was such generally accepted by everyone everywhere because it corresponded to the real facts. There were sometimes also some nice legal things when it comes to sovereignty and what it means and what it does not mean. For example, in former times when England still was a member state of the European Union and John Major had given the English agreement to the Treaty of Maastricht, then somebody went to court and sued John Major for committing or having committed the crime of high treason. That was founded on a law which was made under Henry VIII by the English Parliament and had never been revoked, that everybody who tries, or even everybody who tries to subordinate the crown of England to a foreign power is guilty of high treason, and that, by the way, under Henry VIII meant the death penalty. So you would have probably been cut into several parts, your head being one of them. Now that case went to the House of Lords, I believe, and they decided that if that had been high treason, that act had been committed in the 1970s already, when England became a part of the European Union's predecessor, the European Economic Community, and that the guilty person was then not John Major, but it was his, and he was dead and gone, so it was not a reasonable idea to start criminal proceedings against him. So the basis of their argumentation was, even if conveying sovereignty to somebody else had been an impossible act legally, well, if it had happened effectively, it is now fact, and so sovereignty has gone. So evidently, there are strong indications for, even under the theory of sovereignty, if you take it very serious, it can be shifted effectively. And that is what we probably have all to accept as a given fact. Well, naturally, within the legal texts, you also have rules which say that sovereignty lies with the EU in the areas where the EU has to decide. For example, I recommend to you to take the Treaty on the European Union and take a glance there at Article 4, Paragraph 3 and subparagraphs 2 and 3. There it's clearly said that there are certain areas where the Union has the exclusive right to legislate, and that the member states have to refrain from all measures which might interfere with the EU measures or might hinder the EU measures from taking their full effect. Also, in the Treaty on the Functioning of the European Union, you have rules which say there are exclusive powers where only the EU has the right to act. There are rules which say there are shared competences. If the EU has acted, then the member states are no longer allowed to act in that field. Or there is even a rule which says if there is any legal act of the Union or another reason in the EU legal framework, which makes it necessary or which allows it to conclude a treaty with a foreign state on the EU level, then the member states lose the competence to conclude such treaties individually. So there are certain clear rules which say the member states lose rights to the European Union. So that is clear. And in the national constitutions, usually the competences of the EU are acknowledged. In Germany, for example, that is within the Article 23. The constitutional courts often try to interpret their constitutions in a restricted way, that this is only conveying sovereignty or parts of sovereignty to the EU in a certain restricted way, and that they assume the power or reserve the power to control that mechanism, or to say in certain areas sovereignty has not been effectively passed over to the EU. That is usually a very theoretical approach. By the way, the clearest statement which you can find in a national constitution, which I know, is the Irish Constitution, which clearly says in one of its last articles, in Article 29, no provision of this constitution, really no provision, invalidates laws enacted, acts done, or measures adopted by the states before, on, or after the entry into force of the Treaty of Lisbon that are necessitated by the obligations of member state of the EU, and so on, from having the force of law in the state. So they just say in the beginning, Ireland is sovereign and only God and is above the Irish nation and all that. And in the end, there is a clear admission, okay, no sentence in this constitution ever can hinder any legal act of the EU institutions from taking full effect in the Irish state. The German Constitutional Court, on the other hand, says we try to check if the EU institutions act outside the scope of what Germany allowed them to do, and we interpret what Germany did convey as powers to them, and the arguments brought forward by them are not really convincing. Because what the European Union treaties say has to be interpreted by the European Court of Justice. And if the European Court of Justice said that the treaties say something, that is usually the binding interpretation. That is also accepted. So the Constitutional Court says that is not valid in cases where the interpretation by the EU court could not have been foreseen. On the other hand, naturally, European Union law has its own rules for interpretation, and so if you are familiar with these rules, you can very well foresee certain interpretations, or at least you can allow them to be possible. And so it's rather a weak position. By the way, to give a constitutional court the power to say that EU law is out of scope of what has been allowed would be rather dangerous, because in the long run that opens the doors to negate, to abolish the binding power of EU law at all. It would be a return to, we only follow an obligation if we want to, otherwise we create an argumentation to talk ourselves out of it. And so such a fundamental change of the legal system of the European Union legal framework should not be allowed to be made by a simple gremium of appointed experts, even if they are the highest judges. That should only happen by a formal decision of the highest constitutional and legislating bodies, because that could change the whole coexistence of European states and would in all probability even be able to lead to a war in Europe in the long run. So that would be rather difficult. By the way, legally, such a decision by a national constitutional court would even be difficult to enforce, because under the legal system of the EU law, every national court which has to decide over a matter can always ask the European Union Court for an opinion, and then has to rely or has to follow that information or that answer by the European Union Court when they give their court decision. So, and they even have that right if a higher court has already spoken on the matter and they are dealing with it again. So even if a higher court has already given a decision, a lower court can always address the European Union Court and then deviate from the higher court's decision. So even if the Constitutional Court had ruled on something, the lowest court somewhere could deviate from that decision by just addressing the European Court of Justice and then following its decision. It would not be possible to overrule that. That would be again then ending up in a matter of fact who has more followers. Okay, so in principle, there might be debates about the prevalence of EU law, but in reality, that's never really questioned. You know that the Constitutional Court of Poland tries to question the superiority of EU law in certain aspects. By the way, it's rather shameful. They took over an argumentation which came from the German Constitutional Court. But in principle, that is regarded as highly dangerous, and probably people will restrict such an approach to very, very rare cases. So in reality, prevalence of EU law can be regarded as at the moment unquestioned. Even in normal situations, all constitutional courts uphold the prevalence of EU law. Sometimes there is even the debate of the EU has already evolved into a state. Also, that is a kind of fruitless discussion, because also if you are a state or not is a matter of fact decision, and a matter how people decide to view that. There is sometimes the theoretical approach to say a state is only given if something has competence. That means if you have the competence to decide which institution will have which competences to act. And on that basis, people usually say the member states still decide where the competences are, so the EU is not yet a state. On the other hand, it's clear that if you have a state will have a constitution. The constitution will decide which institution has which powers in that state, and the constitution can only be changed usually under the rules which are laid down by that constitution. Now, if you wanted to see the EU as a state, you could say the EU is a state, and under its present constitutions, all powers lie with the member states, apart from those which have been conveyed or attributed to the central institutions. And under that constitutional framework, the constitution can only be changed with the unanimous consent of all these lower units called member states. This would also give a logical image free of contradictions. So it's a question how you want to define it, and so it's a fruitless discussion. Well, so let's turn to the things which really might matter in practice. You have sometimes heard what's prevalence. There is a prevalence of EU law, and you will have heard the prevalence of EU law does not mean that a contradicting national law becomes invalid. It remains valid. And this is rather puzzling, at least at the first glance. How is it possible that EU law prevails if the national law remains fully in force? So it's not cancelled. That is difficult to understand at the first glance, but the answer is relatively easy when you argue with examples and when you remember that we have always in law, or very often, the situation that two laws give contradicting orders. In such a case, you have clear legal rules which law you then have to follow. For example, general rule and special rule. If general rule and special rule contradict each other, then you have to follow the special rule because it was written especially for this situation, and so the legislator wanted to deviate from the general rule, otherwise it would make no sense. So as far as a special rule deviates from a general rule, the special rule has to be followed, and the general rule only is applied for the rest, where the special rule remains silent. So that is a kind of conflict-solving rule in case where two rules contradict each other. And that's still abstract, so we should illustrate it by examples from practice. The first one, how you can explain how the conflict is solved although both laws remain in force, is, for example, a situation in traffic. Imagine you drive a firefighter's car, and now the place where you intend to park your car has a traffic sign, which means parking or even stopping here is forbidden to everybody at all times. This is a clear binding order. Now, as your car is a firefighter's car, there is a second legal rule which says a firefighter's car may, in case of an emergency, park everywhere. Now there is a strict and clear conflict. The traffic sign says no parking is allowed here, and now your status as a firefighter's car says I may park here. How can that be solved? Here you would again have that conflict-solving rule, which says special law prevails over general law. Everyone is forbidden to park here is a general rule, whereas the rule for the firefighter's car is more designed for the special case and is evidently designed to overrule that general rule. So it would be clear you are allowed to park there. However, the traffic sign and its command remain valid. Wherever you don't have a conflict, the traffic sign still has to be obeyed. So if somebody else wants to park the car there, they are still forbidden to do it. To them, this law or this order is still binding. Also, if you are a firefighter's car, but there is no emergency at hand, then there is no conflict between the two legal rules. The traffic sign and its command remain valid. You are not allowed to park your car there, apart from cases where there is an emergency situation, because only then there is the other order which prevails. In an emergency situation, a firefighter car can park everywhere, but only then. So the thing is, the law which is overruled remains valid. That means for all the situations where you have no conflict, it is still binding. And that is meant by national law remains in force. EU law only prevails in cases of conflicts. So as far as the conflict goes. So let's illustrate what that means in case of a conflict between EU law and member state law in the field of taxation. Imagine that EU law forbids to discriminate against an EU national. But national law says that foreigners have to pay taxes of 30%, whereas taxpayers in the inland only pay 20%. In that case, EU law says I forbid to take more than what an inland taxpayer would have to pay, so I forbid to demand more than 20%. National law says demand 30%. It's impossible to follow both rules at the same time. Now you have to decide for one of the two rules, and here you clearly decide for the application of the EU rule. That means the foreigner has to pay 20%. The same as the inland taxpayer. But the national rule, foreigners have to pay 30%, still remains valid wherever EU law remains silent. Wherever EU law doesn't come into play, the national rule fully applies. For example, if you have a foreigner who is not an EU national, then you don't have EU rules applying to the case, so that national law, take 30%, remains uncontradicted, and so it fully applies. This foreigner will have to pay 30% if you are not able to find any additional rule which also says no, also in that foreigner's case, you have to restrict your tax claims to 30%. So here you can see that if EU law always prevails over national law, it might be of high importance to know where EU law comes into play, because then you can have a contradictory order, or you can have your national law overruled, and very often that can be used as an argument which is in favor of the taxpayer, as in my example here, where the taxpayer can say, okay, I am an EU national, I only pay the same as an inland national would have to pay, so only 20% instead of the 30 which are written in the text of the law. So that is what makes dealing with EU law highly interesting, and that is what we will have to discuss in the rest of our lecture more and more. Thanks for watching, and hope to see you again soon during the next days or so. Goodbye.